If you accidentally, bump into someone on a crowded subway train and they stumble, they fall backward and break their arm, did you just commit a violent crime that could, land you in a federal penitentiary?
That is, wow, that's literally the ultimate anxiety-inducing scenario for anyone just trying to commute to work.
It really is. You're just standing there, holding your briefcase, staring at someone in a full cast, and suddenly you're wondering if you need to call a defense attorney.
Oh, absolutely.
And the answer to that question is buried deep in this incredibly murky wording of Canadian assault law.
Mm.
And what is fascinating and honestly kind of terrifying is that how the justice system evaluates that subway bump is the exact same foundational framework it uses to evaluate a bar fight, a domestic dispute, and even a targeted act of hatred.
Right, because the law isn't just looking at the broken arm. The medical system looks at the broken arm. The justice system is actually trying to peer into your mind in the seconds before that physical contact happened. It's attempting to diagnose human intent.
Welcome to the Deep Dive. I am so thrilled you're spending your time with us today. If you're listening to this right now, you are someone who wants to gain knowledge quickly, thoroughly, and without feeling completely crushed by the sheer volume of information out there.
Yeah, nobody wants information overload.
Exactly. You're looking for multiple perspectives. You want those genuine aha moments, and you want to walk away from this conversation feeling deeply, truly well-informed. So today, we're exploring the complex legal frameworks, the statistical realities, and the very real physical risks surrounding violence and assault in Canada.
And we have a truly comprehensive stack of sources to guide us through this landscape today. We're looking directly at the text of the Canadian Criminal Code, for starters.
The actual legal text.
Yeah, the actual text. Plus, we have detailed legal defense frameworks provided by Zargarian litigation. We're unpacking a 2023 hate crimes unit report from the Saskatoon Police Service, analyzing news reporting on recent police shootings, reading from a memorial list of fallen officers,
And we've got that study, right?
yes, finally, we are going to tear into this deeply fascinating, peer-reviewed academic study from the Facets Journal regarding duty-related bodily harm. It's quite a lineup.
It is. Now, before we take another step, I need to state something very clearly to you, the listener. Because these sources cover incredibly politically and socially charged topics. We are talking about police use of force, systemic justice issues, hate crimes, societal violence. We have to emphasize that we are not taking sides.
Absolutely.
We are not endorsing any specific political viewpoints, whether they lean left, right, or center. Our mission on this deep dive is strictly to impartially report, unpack, and synthesize the ideas and data contained in your original source material. We're here to understand the mechanics of these issues, not to tell you how to feel about them.
Right, because knowledge is only valuable when it's understood clearly and objectively. That's the exact lens we're using today.
So here's our mission. First, we are going to deconstruct how Canadian law actually defines violence, starting with that subway bump. Second, we'll explore how intent, specifically things like hate or bias, fundamentally changes those legal definitions and the consequences that follow.
And the penalties.
Right. And finally, we're going to examine a really striking disconnect in the data, which is the statistical reality of violence committed by police versus the escalating violence committed against them. Okay, let's unpack this.
Let's do it.
So before we can even touch on complex societal trends or, hate crime statistics, we have to start at the absolute bedrock. How does the law define a physical attack? Because I think most of us walk around with a very Hollywood idea of what assault actually is.
We absolutely do. When you hear the word assault, your mind instantly goes to a cinematic extreme. You picture a dark alley, a closed fist, someone getting thrown through a plate glass window.
Yeah, like an action movie.
Exactly. You picture visible, undeniable trauma. But from a legal perspective, that Hollywood image is just the furthest, most extreme end of a really, really wide spectrum.
So looking at the materials from Zargarian litigation and Section 265 of the Criminal Code, how broad is this spectrum? What is the baseline definition?
So Section 265 defines assault as the intentional application of force, or the threat of force, without the other person's consent. And here is the part that catches most people off guard.
Okay.
The source explicitly notes that even a minor touch can ground an assault charge.
Wait, a minor touch? So
Yeah.
me tapping someone on the shoulder aggressively to get their attention in a grocery store line?
If it is an intentional application of force without their consent, yes, it technically meets the threshold.
Wow.
I know, right? The justice system is essentially saying that it isn't just policing injury or blood or bruises, it's policing physical autonomy. You just do not have the right to impose your physical will on another person's body, no matter how slight the pressure is.
That is wild. But here's where the legal terminology gets really dense for me. The law classifies this baseline assault as a general intent offense. I spent, gosh, good 20 minutes reading this section over and over trying to wrap my head around it. What exactly is general intent, and how does it differ from what we normally think of as intending to commit a crime?
It is arguably one of the most misunderstood concepts in criminal law. Let's break it down. In criminal law, you generally have two types of intent. You've got specific intent and general intent.
Okay, specific and general.
Right. Specific intent means you intended not just the action, but the specific outcome of that action. So murder is a specific intent offense. You didn't just intend to pull the trigger, you specifically intended to end that person's life.
Okay, I follow that. So what makes assault different?
Assault is a general intent offense. This means the Crown prosecutor does not need to prove that you intended the consequences of your physical action.
Wait, they don't.
No. They only need to prove that you intended the initial act of applying force. The intent is attached to the muscle movement, not the resulting damage.
So if we use an analogy, it's like throwing a heavy rock into a pond.
Oh, I like that. Go on.
If I stand on the edge of a pond and I intentionally throw a heavy rock into the water, my intent was just to throw the rock. Maybe I just wanted to see a big splash. But if that rock creates a massive ripple, and that ripple travels across the pond and overturns a lily pad where a frog is sitting, I can't stand there and say, well, hold on. I didn't intend to flip the frog.
Exactly.
I just intended to throw the rock. The law says it doesn't matter. You intended the initial action of throwing the rock, therefore you are legally responsible for every single ripple that follows.
That is a brilliant way to conceptualize it. Yes,
Yeah.
If you intentionally push someone during an argument, just a shove to get them out of your face, and they trip backward, hit their head on the curb, and suffer a severe concussion, you cannot use the defense of, oh, I didn't mean to hurt them.
Because the shove was intentional.
Precisely. The courts do not care that you didn't intend the concussion. They only care that you intended the shove. The general intent to apply force was present, so you are responsible for the entire chain reaction of harm.
Which brings us all the way back to our subway scenario. I bump into someone, they fall, their arm breaks.
Yeah.
I am terrified I'm going to prison. Does the general intent rule mean I'm guilty because my body made contact with theirs and a broken arm was the ripple?
No, and this is where the precision of the law saves you. Remember the definition we just talked about? The intentional application of force.
Oh, right.
In the subway scenario, the train lurches, you lose your balance, and you collide with someone. You did not intend to apply force. Physics, gravity, and a moving train applied the force.
So my muscle movement wasn't a choice.
Exactly. Your muscle movement wasn't a deliberate choice to strike them. Because the initial act lacked intent, there is no assault, regardless of how horrific the broken arm is.
Okay, I can breathe a massive sigh of relief. So the baseline is all about that intentional spark. But once that spark is there, once the act is intentional, the criminal code doesn't just treat every assault equally. It breaks it down into these escalating scales of severity, and the penalties ramp up dramatically.
They do, and they ramp up based on two primary factors: the tools you bring into the equation and the physical damage you leave behind.
Let's walk through that ladder. The foundation is Section 266, which is simple assault. That's the shove we talked about, the slap. Or even just a threatening gesture like raising a fist and stepping towards someone, making them flinch.
Yeah, just the threat is enough.
Right, and the maximum penalty there is up to 5 years in prison. But then we take a step up to Section 267A, assault with a weapon. This carries up to 10 years. And when I was reading the Zargarian brief on this, my definition of a weapon was completely shattered.
Because you're probably thinking of firearms and switchblades.
Exactly. I think of things manufactured specifically to cause harm. But the legal definition here is astonishingly broad. It notes that a weapon could be a car. It could be a beer bottle picked up off a bar. It could be a heavy book thrown across a room.
Anything, really.
Yeah. Basically, if you use any physical object to apply or threaten force, you've suddenly doubled your potential prison time. Why is the law so aggressive about someone throwing a coffee mug?
Because the moment you pick up an object, you have introduced a force multiplier into a volatile situation. I mean, human skin and bone have natural limits. But when you introduce glass, steel, or heavy blunt objects, the potential for lethal harm skyrockets exponentially.
It changes the math of the fight entirely.
Totally. The justice system is essentially trying to create a massive deterrent against escalating a bare-knuckle conflict into an armed conflict, regardless of what the arm happens to be. If you use your car to intentionally bump a pedestrian who is, say, walking too slowly in a crosswalk, you didn't just nudge them. Legally, you assaulted them with a 2-ton weapon.
Wow. That reframes so many road rage videos you see online. You aren't just being a jerk. You are committing an offense that carries a decade-long maximum sentence.
It's extremely serious.
Which brings us to the next rung on the ladder, sections 267B and C. Assault, causing bodily harm, and assault by choking. These also carry up to 10 years. Now, bodily harm makes sense. That's the broken nose, the lacerations, anything that requires medical attention. But the specific carve-out for choking, the defense materials spend a lot of time on this.
They do, yeah.
They point out that choking, suffocating, or strangling is treated with extreme, almost unparalleled seriousness by the courts, particularly in the context of domestic violence.
It is a critical distinction in the law. For a long time, choking might have just been lumped in with general assault, but criminologists and legal scholars pushed for this specific categorization because of what choking actually represents psychologically and statistically.
So,
Well, statistically, in domestic abuse situations, non-fatal strangulation is one of the highest known predictors of future homicide.
that is terrifying.
It really is. If a partner chokes you today, the statistical probability that they will eventually murder you increases astronomically. And psychologically, think about the nature of the act. A punch is a strike. But strangulation is a sustained, intimate assertion of total control over another human being's most vital function, their breath.
Wow, yeah.
You are holding their life in your hands, watching them struggle, and choosing whether they get to live or die in that moment. The law carves it out specifically because it is a massive flashing red siren indicating severe escalating risk.
That is incredibly sobering. It really highlights how the law isn't just punishing the past, it's trying to prevent a fatal future.
Exact.
And that leads us to the absolute top of the non-sexual assault ladder, which is Section 268, aggravated assault. It carries up to 14 years in prison. And the language here is almost medieval. It involves wounding, maiming, disfiguring, or endangering the life of the complainant. Zargarian notes that in the most extreme cases, this charge approaches attempted murder in its gravity.
It does, because the threshold for maiming or disfiguring requires permanent, life-altering damage. We aren't talking about a scar that fades.
Right.
We are talking about the loss of a limb, the permanent loss of vision, severe burns. The 14-year maximum reflects society's condemnation of an act that permanently alters someone's existence.
And running parallel to all these physical assaults are the sexual assault provisions, falling under Sections 271 through 273.1. The penalties here are incredibly steep, with maximums ranging from 10 years to life in prison, depending on the age of the victim, whether weapons were used, and whether the assault was aggravated by wounding or maiming.
And the definitions are very strict.
Yeah, what really stood out in the sources is how the legal definition of consent operates here.
Yeah.
I feel like in pop culture, there is constant debate about blurred lines and miscommunication. But reading Section 273.1, the law doesn't seem to think the lines are blurry at all. It is uncompromising.
It is incredibly rigid by design. The law states that consent must be the voluntary agreement to engage in the sexual activity in question, and, crucially, it must be present at the time the activity takes place.
Meaning you can't consent on Tuesday for something that happens on Friday if you change your mind in between.
Precisely. Consent is continuous and revocable at any millisecond. Furthermore, the law explicitly outlines scenarios where consent legally cannot exist no matter what words are spoken.
Okay, so like when?
There is no such thing as implied consent. If a person is unconscious or severely intoxicated to the point of lacking capacity, they cannot consent.
The sources also note that no consent is obtained if the accused induces the agreement by abusing a position of trust, power, or authority. So like a boss leveraging a promotion or a doctor abusing their position with a patient.
Yes, exactly.
And importantly, an agreement expressed by someone other than the complainant is entirely invalid. You cannot have a proxy for your bodily autonomy.
Right. It systematically removes the gray areas that perpetrators often try to hide behind. The law is very clear on what constitutes a violation. But, and this is a massive but in the realm of criminal justice, being charged with one of these offenses, having the police read you your rights, is not the same as being convicted in a court of law.
Right. And this is where the Zargarian litigation sources give us a really fascinating look behind the curtain at the pre-charge stage and the realities of defense strategy. They outline something that I think would shock a lot of people who assume the justice system works like an episode of Law and Order.
No, for sure.
They note that a formal criminal charge can often be approved by Crown Counsel based on one person's word alone.
It absolutely runs counter to the public perception. We are conditioned to think you need a smoking gun, a bloody glove, and a room full of eyewitnesses to ruin someone's life with a criminal charge.
Exactly. I assumed it was innocent until proven guilty, requiring a mountain of empirical evidence just to get the ball rolling. How can someone's mere word be enough to trigger the full weight of the state against an individual?
Because you have to look at the reality of where these crimes occur. The vast majority of assaults, particularly domestic violence and sexual assault, do not happen in crowded public squares with CCTV cameras recording from 3 angles.
All right.
They happen behind closed doors, they happen in bedrooms, in private homes, in isolated areas. If the justice system required third-party witnesses or video footage to lay a charge, 90% of violent crimes would simply go unprosecuted.
That makes total uncomfortable sense.
The standard for laying a charge isn't proof beyond a reasonable doubt. That's the standard for conviction at a trial. The standard for the Crown to approve a charge is whether there is a substantial likelihood of conviction, and if it is in the public interest.
So the bar is lower to start.
Yes. If an investigator takes a statement from a complainant, and that statement is detailed, consistent, and deemed credible, that individual's word is the evidence, and it is entirely sufficient to arrest someone, fingerprint them, and bring them before a judge.
Which makes the defense phase of the justice system so incredibly critical. If you can be charged based on a narrative, the defense is entirely about challenging the integrity of that narrative. The sources outline several common legal defenses, and the mechanics of them are fascinating.
Let's hear them.
Take self-defense, for example. It isn't just a free pass to win a fight. You have to prove that your response was reasonable to the threatened force. If someone shoves you, you can't pull out a baseball bat and break their knees and claim self-defense. The response has to be proportionate.
Exactly. It's a legal balancing act.
Then there's consent, which we touched on, but it's particularly relevant in physical assault cases involving usual fights or sporting events. You consent to a certain level of violence when you step into a hockey rink, but you don't consent to being slashed in the face with a stick after the whistle blows.
Right. The context of the consent matters.
Then there's accident, which goes back to our subway scenario, proving a lack of intent. There's mistaken identity, proving you simply weren't the person in the dark alley. But the most complex one seems to be witness credibility.
Oh, absolutely.
If the entire charge is based on someone's word, the defense has to dismantle that word. The sources talk about digging into prior inconsistent statements, motives to lie, or the role of intoxication.
And this is where trials become incredibly arduous and emotionally taxing for everyone involved. Let's put a hypothetical out there. Imagine a bitter, highly contested divorce and custody battle.
Okay.
One party alleges a historical assault from 3 years ago. There is no physical evidence, no hospital records, just the allegation.
Right, just their word.
The defense lawyer's job isn't necessarily to call the complainant a liar outright. Their job is to subpoena text messages from that era looking for contradictions. They look at cell phone tower data, where the two parties, even in the same city on the date alleged, they look at financial records. They explore the motive. Does a criminal conviction guarantee full custody of the children?
Oh, I see.
By pulling at the threads of the narrative, the defense tries to introduce reasonable doubt into the mind of the judge or jury.
And beyond the facts of the case, the defense can also attack the process of the investigation through charter rights violations. This is a huge pillar of Canadian law. If the police arrest you without reasonable grounds, or if they search your home without a proper warrant, or if they interrogate you and fail to advise you of your right to call a lawyer, the evidence they gather can be entirely excluded from the trial.
And if the evidence is excluded, the Crown's case often collapses and charges are stayed entirely. It is a vital mechanism to ensure that the state, with all its power and resources, plays strictly by the rules when attempting to strip a citizen of their liberty.
But not every case ends in a dramatic, Hollywood-style courtroom verdict of guilty or not guilty. In fact, the sources point out that many cases are resolved without a trial through alternative measures.
Which is often a more pragmatic approach, especially for first-time offenders or less severe incidents. I mean, the justice system is overloaded. If every simple assault went to a full trial, the courts would grind to an absolute halt.
So how do these alternatives work mechanically? For instance, what is an alternative measure or a diversion program?
Essentially, the Crown says, look, we have enough evidence to prosecute you, but we believe society is better served by rehabilitating you.
Yeah.
So the accused agrees to take responsibility, usually by completing anger management counseling, performing community service, or writing a letter of apology. Once they complete the program, the Crown drops the charges. No trial, no criminal record.
And then there are peace bonds. I've heard this term a lot in the news. How does a peace bond divert someone from a criminal record?
A peace bond is fundamentally about prevention rather than punishment. Let's say two neighbors get into a heated, shoving match over a property line. The police are called, an assault charge is laid. Instead of going to trial, the accused agrees to sign a peace bond.
What does that entail?
It's a court order demanding they keep the peace, be of good behavior, and perhaps not communicate with that specific neighbor for 12 months. In exchange for signing the bond and agreeing to those strict conditions, the Crown withdraws the criminal charge.
So they never admit guilt to the assault, but they are legally bound to back off.
Precisely. And if they breach the peace bond by harassing the neighbor again, the breach itself is a criminal offense.
Got it. Now, the final resolution the sources mention is an absolute or conditional discharge. This one is tricky. It is an actual finding of guilt. A judge says, yes, you did commit the assault, but it still results in no permanent criminal record. Why would a judge find someone guilty but not give them a record?
Because the judge determines that while the act occurred, burdening this specific individual with a lifelong criminal record is disproportionate to the crime, and it's not in the public interest.
Give me an example of that.
Okay, imagine an 18-year-old with a flawless record who gets into a minor scuffle at a high school grad party. A criminal record might prevent them from getting into university, traveling internationally, or getting a job. A judge might grant a conditional discharge. You are guilty. But if you stay out of trouble for a year, this conviction will be purged from your record.
So if we look at this entire legal architecture, from the subway bump to the definition of weapon to the pretrial diversions, the whole anatomy of assault in Canadian law is this incredibly intricate attempt to calibrate punishment. It is trying to match the exact physical severity of the act with the immediate context in which it happened.
That is a perfect summary. The law is obsessed with the what and the how of the physical altercation.
But as we are about to see, the justice system doesn't just stop there. It doesn't just care about the mechanics of the punch. It cares deeply, profoundly about the sociological why behind that punch.
The motivation.
Right. If proving the physical act of assault is step one, how on earth does a courtroom prove the emotional motivation behind it? Because proving I pushed you is one thing. Proving I pushed you because of a hateful bias requires entirely different evidence.
It really does.
This brings us to a really illuminating document, which is the Saskatoon Police Service's 2023 Hate Crimes Unit Report.
This report is a fascinating window into how a modern police service actively adapts to evolving societal tensions. It shows the mechanics of how police attempt to quantify something as abstract and insidious as hatred.
Before we dig into their data, we need the legal framework again, because hate is a big, emotional word. But how does the criminal code specifically define who can be a victim of a legally recognized hate crime?
It's very specific.
Yeah, Section 318, subsection 4 of the Criminal Code defines an identifiable group. It states that this is any section of the public distinguished by color, race, religion, national or ethnic origin, age, sex, sexual orientation, gender identity or expression, or mental or physical disability.
It is an exhaustive list, and it is deliberately designed to protect the core, immutable characteristics of human identity. You can hate someone because they are a fan of a rival sports team, and if you hit them, it's an assault. But it isn't a hate crime because being a sports fan is not an immutable characteristic of your identity under Section 318.
That distinction is crucial, and the Saskatoon Police Report is very careful to distinguish between three very different categories of events that they track. First, you have a definitive hate crime. This is a criminal offense like assault or vandalism or uttering threats that is motivated in whole or in part by bias, prejudice, or hate based on those identifiable factors we just listed. The hate is the engine driving the crime.
Then you have a suspected hate crime. This is a scenario where a criminal offense has clearly occurred. Say, a synagogue is spray-painted with graffiti, and there is a reasonable suspicion that it was motivated by hate.
Right, but no proof.
Exactly. Because there are no witnesses and the graffiti might be somewhat ambiguous, it cannot be legally proven beyond a reasonable doubt that hate was the sole motivator. The police suspect it, but they can't confirm it.
And then there's the third category, which I found the most interesting, the non-criminal hate incident. This is crucial to understand. This is an action that is clearly motivated by hate or bias, but the action itself does not cross the threshold into a chargeable criminal offense.
Yeah, the report gives a great example of this.
Yeah, imagine a dispute between neighbors over a barking dog. It gets heated, and one neighbor yells a vile racial slur at the other.
It is undeniably hateful, it is abhorrent, and the police will be called to investigate.
Exactly, but it might not be a crime. Being racist, unfortunately, is not inherently illegal in Canada unless it crosses specific thresholds, like uttering a threat of violence or publicly inciting hatred against a group. Yelling a slur in a private neighbor dispute is a non-criminal hate incident.
So the natural question is, if it isn't a crime, why are the police spending time and resources tracking it?
Right. Why bother writing a report if you can't arrest anyone?
Because tracking non-criminal incidents allows a police service to build a sociological heat map of their city. It serves as an early warning system. If you see a massive spike in non-criminal racist incidents in a specific neighborhood, you know the community temperature is rising.
That makes sense.
You know that if tensions aren't addressed through community outreach or mediation, those non-criminal incidents are eventually going to boil over into criminal violence. It is proactive policing rather than just reactive.
And that proactive mindset is exactly why the Saskatoon Police Service developed a dedicated, specialized hate crimes unit in January of 2022. They realized they had a gap in detection, a gap in supporting these specific victims, and a need to accurately track the temperature of their community.
It was a necessary evolution.
So let's look at the actual data this unit gathered, because this is where the statistics get incredibly jarring, and they require some real critical thinking to unpack. In 2022, the Saskatoon Police recorded 208 hate-related events. In 2023, that number jumped to 403 events.
It practically doubled in a single 12-month period.
It did. And let's break down those 403 events from 2023. Of that total, 64 were classified as either a confirmed hate crime or a suspected hate crime. Specifically, 36 were confirmed hate crimes, 20 were suspected, 4 involved mischief to religious property, 3 were public incitement of hatred, and 1 involved advocating genocide.
Wow.
Ultimately, out of all of this, 16 events resulted in criminal charges where hate was recommended to the Crown as an aggravating factor. Now, I want to pause here. Because if I'm reading a newspaper headline that says hate events jump 100% in 1 year, my immediate visceral reaction is absolute panic.
Yeah, true.
I'm going to think, oh my goodness, society's completely broken down. People just became twice as hateful, twice as violent overnight. But the police report itself explicitly warns the reader that jumping to that conclusion based on the numbers alone is highly deceptive. Why?
Well, this is a classic vital lesson in data literacy. It highlights the danger of reading statistics without understanding the methodology behind them. The numbers doubled, not necessarily because the actual occurrences on the street doubled, but because the method of detection fundamentally changed.
Walk me through what changed.
The report explains that in 2023, the police service assigned a dedicated constable who was working full-time in a duty-to-accommodate position. This constable was given a very specific, singular mission: sit down, search the vast internal police database, track, read, and correctly categorize files that previously would have slipped completely through the cracks.
Oh, wow. Okay, I see where this is going.
Think about policing before this unit existed. A patrol officer is running from call to call. They respond to a vandalism complaint downtown, a storefront window is smashed, and a slur is painted on the brick.
Right, chaos on the street.
Exactly. The officer writes it up rapidly as standard mischief, files the report, and races to the next emergency call. The hateful element was absolutely present, but because the officer was overworked and not specialized, it wasn't properly tagged with the specific hate crime statistical code in the computer system.
So the data was always there, it was just buried under generic labels.
Precisely. What this dedicated constable did was act as an auditor. They went through thousands of standard assault, mischief, and disturbance reports, reading the narrative and saying, wait a minute, this wasn't just a random assault. The suspect targeted this person because of their sexual orientation. This needs to be reclassified.
That's fascinating.
Yeah, the doubling of the numbers represents a crisis of historical reporting and data management being solved. It illuminates the true baseline of what was already happening in the community, rather than indicating a sudden, massive spike in new hateful occurrences.
That makes total sense, and it really changes how you view a statistical surge. But it brings up another massive question. How does that dedicated constable, or any investigator on the street, actually determine if an event was motivated by hate? Because perpetrators rarely hand over a signed confession stating, I did this because of racial bias.
Right, they aren't filling out a survey afterward.
Exactly. The report details the criteria they use, which comes from the Canadian Centre for Justice Statistics, or the CCJS.
Hmm.
And reading this list, it is deeply nuanced. It's not just a checklist. It's a deep contextual analysis.
What kind of context?
They obviously look at what was said, slurs or hate speech, but they also look at the timing of the slur. Was it yelled at the beginning of the altercation, indicating it was a motivation? Or was it yelled at the very end of a fight over a parking space, just as a cheap insult? They look at the history between the parties. Has this suspect harassed this victim before? They look at the visibility of the victim.
That visibility aspect is key. They ask, is this victim the only person of that specific demographic characteristic in the neighborhood? If so, does that indicate they were singled out? Was it a random targeting on a public street, or did the suspect go out of their way to find this specific individual?
Right.
They even look at the severity and the context of vandalism. If a statue is defaced, what specific symbols were used, and what is the historical context of those symbols?
What's fascinating to me here is that this criteria requires a police officer to act almost like a sociologist or a historian. They aren't just measuring a crime scene with a tape measure. They are evaluating the psychological, historical, and social environment of the crime.
It's incredibly complex work.
And the reason they do this, the reason they go through all this painstaking analysis, matters immensely in the courtroom. It all comes back to a specific piece of legislation, Section 718.2ai of the Criminal Code. The report mentions this section as the ultimate destination for their investigations. What exactly does this section do?
It is the mechanism that bridges the gap between social intent and legal punishment. Section 718 deals with the principles of sentencing. It states that if the Crown prosecutor can prove that hate, based on those identifiable factors, was wholly or in part an aggravating factor in a criminal offense, the judge must consider that during sentencing.
So it forces the judge's hand.
Yes. Let me give you a concrete example. Two men get into a fist fight outside a bar because one spilled a drink on the other. One man suffers a broken jaw. The offender is convicted of assault causing bodily harm. The judge might sentence him to 6 months in jail. The physical act was an assault. The motivation was anger and alcohol.
Okay, standard bar fight.
Now imagine the exact same physical fight resulting in the exact same broken jaw. But this time the offender targeted the victim specifically because they were holding hands with another man and yelled homophobic slurs before throwing the punch.
The physical damage to the victim's face is identical in both scenarios.
Yes. But the damage to society is vastly different. The first assault injured one man. The second assault was designed to terrorize an entire community. Section 718.2 mandates that the judge must recognize this deeper societal injury.
I see.
The judge takes that baseline 6-month sentence, applies the aggravating factor of hate, and increases it, perhaps, to 2 years. The physical act is the same, but the sentence is aggravated to reflect the malicious intent.
So we have established that the justice system is incredibly sensitive to the nuances of violence when citizens harm one another. It weighs the weapons, it evaluates the intent, it tracks the societal hatred. But what happens when the violence is directed at the very people tasked with enforcing all of these complex laws?
The police themselves.
Exactly. What happens when the target is a police officer? Our sources pivot us toward a stark, frankly alarming trend regarding violence against peace officers in Canada.
It is a dramatic shift in perspective. We are moving from analyzing how the public is protected to analyzing the severe physical risks faced by the protectors themselves.
Let's look at the reporting from 980 CJME. The article details a highly volatile incident in Melville, Saskatchewan. 2 RCMP officers responded to a call, and it rapidly escalated into a lengthy armed standoff with a 55-year-old suspect named Marcus Dodge. During this standoff, both officers were seriously injured by gunfire. Dodge was subsequently arrested and charged with attempted murder, aggravated assault, and discharging a firearm with intent.
And while that specific incident is a horrific example of lethal violence, the commentary from police leaders quoted in the article suggests that the Melville shooting is not an isolated anomaly. It is the extreme end of a much broader statistical wave of violence.
That's what caught my attention. Rob Fair, who is the president of the National Police Federation, lays out some jaw-dropping numbers in this article. He states that violence directed at police officers has increased by 50% over the past decade. He quantifies that as 14,000 assaults annually across the country.
14.
But the way he phrased the statistic next is what really stuck with me. He said that statistically, every single police officer in the country is assaulted once every 5 years.
Let that sink in. It is an occupational hazard that is almost mathematically guaranteed.
And Cam McBride, the Saskatoon police chief, adds a vital operational context to those numbers. He says that in modern policing, there is no such thing as a routine call anymore. What starts as a minor traffic stop for a broken taillight or a simple noise complaint at an apartment building can instantly, unpredictably escalate into a life-or-death struggle.
That unpredictability is huge.
He also noted something really poignant about public perception that I had never considered. He mentioned that because officers know these statistics, because they know any interaction could turn violent, they have to maintain this hyper-elevated situational awareness for their own safety.
Right.
They are constantly scanning hands, watching waistbands, checking exits. But the public, who isn't living in that state of hypervigilance, sometimes misperceives that guarded posture as the officer being dismissive, cold, or rude.
It's a tragic disconnect. The public wants a friendly neighborhood cop, but the officer is just trying to survive an inherently unpredictable environment so they can go home to their family.
I understand that disconnect.
Yeah.
But I have to push back on this broader conversation, or at least voice my absolute bewilderment at these statistics. When I hear 14,000 assaults a year against a single profession, it is hard to wrap my head around the societal reaction.
What do you mean?
If that level of violence happened in literally any other profession, say accounting or teaching or nursing, it would be declared a national state of emergency. Pundits would be screaming from the rooftops. There would be royal commissions. Why is this staggering level of violence treated as just part of the job for police? Why is it seemingly accepted?
If we connect this to the bigger picture, that is a profound question. And Rob Forer points directly at systemic issues within the criminal justice system itself as the root cause of this escalating danger. He argues that current legislative frameworks regarding bail decisions and a failure to adequately address chronic repeat offenders mean that individuals with a high propensity for violence spend more time on the street rather than in custody. It is a matter of mathematical probability. If violent offenders are out in the community, the probability of police having violent encounters with them increases.
He also points to structural and resourcing issues, right? Particularly in rural areas.
Yes. The rural staffing model is a massive vulnerability. In major cities, if an officer gets into a physical altercation, backup is usually 60 seconds away.
Because there's officers everywhere.
Exactly. But in rural Canada, officers are frequently required to respond to remote, potentially volatile locations entirely alone. They might be driving down a dirt road in the middle of the night to a domestic dispute, knowing that the nearest backup unit is 45 miles and 40 minutes away.
That is terrifying.
It creates a perfect storm of vulnerability. The isolation emboldens offenders and exponentially increases the danger to the lone officer.
Now, earlier we talked about how the criminal code escalates penalties based on context. Does the law offer specific protections for police? It's not like the law is silent on this violence, is it?
The law is very specific, and it recognizes the unique role of law enforcement. The protections are built directly into the code. Section 270 specifically covers assaulting a peace officer.
Okay.
Section 270.01 elevates the charge and the penalty if a weapon is used or if bodily harm is caused to the officer. Section 270.02 covers aggravated assault of a peace officer wounding or maiming them, which carries a maximum penalty of 14 years. There is even a specific section, 270.1, for disarming a peace officer, recognizing the extreme danger of someone trying to take an officer's duty weapon.
And the defense materials we reviewed noted a relatively recent addition to the law, Section 270.03. This section mandates that any sentence handed down for assaulting law enforcement must be served consecutively to any other punishment arising from the same event.
Right, consecutive sentences.
So if you rob a bank and then assault the police officer who arrests you, you don't get to serve those sentences at the same time. You serve the robbery sentence, and then the assault on police sentence begins. The legal tools are there to deter this violence.
The tools exist on paper, yes. But the physical reality on the ground, in the moment the violence occurs, remains incredibly dangerous regardless of what the criminal code says.
And we cannot and should not talk about this purely in terms of abstract statistics or legal subsections. The ONGIA list of fallen officers that we reviewed brings the human element to the absolute forefront. These are not numbers. These are individuals who made the ultimate sacrifice in the line of duty.
It is deeply sobering to read through the names, the dates, and the circumstances.
It truly is. Just looking at recent years, Constable Frederick O'Brien killed in British Columbia in 2023 while executing a search warrant. Constable Shailing Yang, a mental health and homeless outreach officer, killed in Burnaby in 2022. Constable Heidi Stevenson, who died protecting the public during the mass shooting in Nova Scotia in 2020. There are dozens of names on this list, stretching back years. It grounds every single statistic we've discussed in the ultimate tragic reality of what it means to put on that uniform.
And acknowledging this grim reality, acknowledging the genuine lethal threat that officers face daily, sets up what is arguably the most complex, counterintuitive, and provocative part of our entire deep dive today.
Okay, let's get into it.
We have established, with concrete data and tragic examples, the escalating crisis of violence against police. Now we must turn our attention to a massive, peer-reviewed academic study that attempts to measure the exact opposite, the rate of violence committed by police and how that reality compares to public perception.
This brings us to the studies from the Facets Journal, authored by Carlton and colleagues in 2025. And I have to say, reading this study was an absolute paradigm shifter for me. It challenged almost everything I thought I knew about societal violence.
It's a heavy read, for sure.
The researchers set out to measure something very specific. They didn't just want to measure every time a police officer used force, because the law authorizes police to use force to effect an arrest or protect the public. They wanted to measure unlawful, excessive force.
Right. They created a very specific metric, and we need to break down the acronym because it is the foundation of their entire paper. They measured DRBH involving FELSOP.
Let's spell that out slowly so we're all on the same page.
Good idea. DRBH stands for duty-related bodily harm. This means serious physical injury or death caused by an officer while on duty.
Okay.
And FELSOP stands for force exceeding legally approved standard operating procedures or code of conduct violations. So when you put it together, they are measuring incidents where a police officer caused serious bodily harm to a citizen by using force that violated the law, violated their training, or violated their professional code of conduct. They are measuring undeniable illegal police violence.
Got it. Now, to give this data any kind of meaningful context, the researchers needed a comparator. They needed another profession that deals with life, death, and public service to compare the error rates against. They chose a metric called AHH, avoidable hospital harm.
Which is very different.
Yeah, this tracks patient injuries or death that occur during a hospital stay that could have been completely avoided if medical best practices and standard operating procedures had been followed. So medication errors, surgical mistakes, preventable infections.
It's a metric of professional error resulting in severe harm to a civilian.
Exactly. Now, before we look at the actual numbers, the researchers did something brilliant. They surveyed the public, specifically university students, to gauge their perception of police violence. They asked the students, out of all the millions of encounters police have with the public every year, in what percentage of those encounters do you think police use their firearms?
And what did they say?
The students estimated that police use firearms in about 2% of their public encounters.
Now, on the surface, 2% sounds like a tiny number. It sounds
Right.
low, but you have to apply that to the sheer volume of police interactions.
Right. I did the math on this while reading the study. If police have 10 million interactions with the public a year, 2% would mean they are shooting their guns 200,000 times a year.
Which is astronomical.
If you put 10,000 police interactions into a massive football stadium, the public believes 200 of those interactions end in gunfire. It would be an absolute bloodbath. It would be a war zone.
So what is the statistical reality according to the Facets data?
The reality is that firearms are used in approximately 0.01% of encounters. Out of that stadium of 10,000 interactions, a firearm is used in exactly one. The public perception is wildly astronomically disconnected from the mathematical truth.
That's incredible.
But the data gets even wilder when we look at the core metric, DRBH involving FELSOP versus avoidable hospital harm. Between 2014 and 2023, the rate of police causing illegal or excessive serious harm to a citizen was 1.89 incidents per 100,000 police occurrences. Yes. Concurrently, during a similar time frame, the rate of avoidable hospital harm was 5,566.67 per 100,000 hospitalizations.
Let those numbers sit in the air for a moment. 1.89 incidents per 100,000 versus over 5,500 incidents per 100,000. The disparity is staggering.
And when it comes to actual fatalities, the numbers are just as severe, and they loop back to the violence against police we discussed earlier. The researchers looked at a 23-year period from the year 2000 to 2023. In that time frame, 47 police officers were killed by intentional acts of violence from the public.
47 officers.
In that exact same 23-year time frame, how many police officers in Canada were criminally convicted of actions resulting in the death of a member of the public? 3. Statistically, a police officer in Canada is roughly 23.5 times more likely to be murdered on duty than they are to be convicted of causing an illegal, fatal harm to a citizen. Furthermore, the study notes that since 2012, when you look at all the independent civilian police oversight agencies across the country, the watchdogs that investigate police, the rate of criminal charges actually laid against police has stabilized at less than 0.08% of occurrences, less than 1/10 of 1%.
This data creates massive, uncomfortable cognitive dissonance for anyone who regularly consumes modern media. Because the dominant media narrative and the general public discourse on social media often paints a picture of pervasive, systemic, and constant police violence against the public.
Yeah, that it's an epidemic.
Exactly. The narrative suggests it is an epidemic. Yet, the hard, peer-reviewed data shows it is an exceptionally rare occurrence rate, especially when compared to other high-stakes public service professions.
The researchers don't just present the numbers and walk away. They dig deeply into why this massive disconnect exists between the reality and the narrative. And they identify a very specific psychological phenomenon at play here called the fundamental attribution error.
Yes, I wanted to get into this.
Can you explain how they apply this concept to policing versus healthcare? Because this was the part of the paper that really blew my mind.
It is a brilliant application of psychology. The fundamental attribution error is a well-documented human tendency. When we observe someone else make a mistake or cause harm, we tend to overestimate personality factors, like they did it because they were a bad person, and we underestimate situational factors. They did it because they were under extreme stress or the system failed them.
Okay, that makes sense.
The study points out that when avoidable hospital harm occurs, when a patient is severely injured or dies due to a tragic medical error, the media and the public generally grant healthcare workers an assumption of beneficence.
Beneficence meaning we assume they meant well. Nobody thinks a nurse woke up, went to the hospital, and maliciously planned to give a patient the wrong medication.
Exactly. When a medical tragedy happens, we look at the system. We say, the nurse was overworked, the hospital is under-resourced, they were doing a 16-hour shift, the system failed. We attribute the harm to situational factors.
Yeah, Rick.
But conversely, when a police officer causes duty-related bodily harm, the fundamental attribution error kicks into overdrive. The media discourse often entirely strips away the situational context. They ignore the chaos of the scene, the split-second decision-making required, the potential lethal threat the officer was facing, or the lack of backup.
Right.
Instead, the harm is immediately attributed to individual malice. The officer was assumed to be inherently bad, inherently violent, or inherently biased, rather than a professional operating in a highly volatile, under-resourced environment where a tragic error was made.
And the researchers argue that the consequences of this skewed narrative are devastating. They explicitly state that this decontextualized anti-police rhetoric actively damages police mental health. It leads to severe burnout.
It definitely would.
Yeah, and it ruins recruitment and retention efforts, meaning it is becoming harder and harder to put good, qualified officers on the street to protect communities. And perhaps most tragically, they argue it actively undermines community engagement and efforts toward Indigenous reconciliation because it fosters a deep, pervasive mistrust that defies the actual statistical reality of the danger.
It's a vicious cycle.
But wait, I have to play devil's advocate here. I can hear people listening to this and objecting. Isn't comparing a hospital to a police arrest fundamentally comparing apples to oranges?
It's a fair question.
I mean, a hospital is a controlled, sterile environment meant entirely for healing. It is equipped with bright lights, heart monitors, and teams of highly educated experts working collaboratively. An arrest is inherently violent and volatile. It often occurs in dark, uncontrolled environments, in alleys or on highways, with uncooperative, sometimes armed individuals who are actively fighting back. Is it really intellectually fair for these researchers to use hospital harm as a comparator to police violence?
This raises an important question, and it is a completely valid pushback. The researchers themselves acknowledge the limitations of their study. They note that the hospital data from CIHI excludes the province of Quebec for methodological reasons, and it relies heavily on self-reporting, which can skew numbers.
Right.
And yes, the environments and the mandates of the professions are vastly different, but the researchers are very clear. They aren't trying to equate the jobs. They aren't saying arresting a suspect is the same as performing a surgery.
Okay, so what are they saying?
They are using the comparison to highlight the hypocrisy in the public and media discourse around professional error.
Ah, I see. It's not about the action. It's about our reaction to the action.
Precisely. Both professions involve public servants intervening with citizens who are in varying levels of acute distress. In both professions, there is a statistical risk that the citizen could be injured or die as a function of the service being provided.
That's true.
The profound point the Facet study makes is this. When a medical error occurs, the public response is a call to properly fund, support, and train the healthcare system so they can do better. When a policing error occurs, the public response is a call to defund the system, enact pervasive systemic reform, and criminally charge the individual officer.
The reaction is completely flipped.
Exactly. The researchers are simply arguing that police officers, absent a clear criminal conviction proving otherwise, deserve the exact same assumption of beneficence and situational understanding that we rightfully afford our healthcare workers. They deserve the benefit of the doubt that they are trying to do a difficult job in an imperfect system.
Wow. That entirely shifts how you look at the evening news. It forces you to look past the headline and ask about the context. We have covered a tremendous amount of ground today.
We really have.
We started at the absolute bedrock of the criminal code, unpacking the surprising reality that assault isn't just about injury, but the intentional application of force. We explored how the justice system evaluates the severity of weapons, the critical danger of choking, and the uncompromising nature of consent.
From there, we looked at how intent alters the legal landscape. The Saskatoon police data showed us that understanding hate crimes isn't just about counting broken windows. It's about evaluating nuanced social context, applying the CCJS criteria, and understanding how a simple change in data collection, like adding one dedicated constable, can reveal hidden realities in a community.
Which brought us to the front lines. We confronted the undeniable statistical reality of the danger officers face 14,000 assaults a year, driven by systemic issues in bail and rural staffing, grounded by the sobering, tragic memory of fallen officers who gave everything.
And finally, we unpacked the facets study, which forced us to confront the massive dissonance between the public narrative of police violence and the statistical truth, highlighting the fundamental attribution error that shapes so much of our media consumption.
And that brings us to why all of this matters to you, the listener. Why did we take this deep dive today? Because whether you are reading a news headline about a local arrest, analyzing national crime statistics released by the government, or participating in a community safety debate at your local town hall, you now have the legal framework and the statistical context to see past the emotional rhetoric.
You're equipped to handle the nuance.
Exactly. You understand the profound legal difference between a non-criminal hate incident and an aggravated assault. You understand the statistical rarity of police misconduct compared to the genuine daily risks they face to maintain order. You are equipped to ask better questions.
That's the goal.
But I want to leave you with a final provocative thought, something to chew on that builds on everything we've discussed today regarding intent and context. As our society rushes toward the future, there is a massive, well-funded push in the tech world for algorithmic justice and AI-driven predictive policing.
Oh, yeah.
The argument is that we want machines to eliminate human bias from the justice system. We want cold, hard logic. But based on everything we've unpacked today, how will an artificial intelligence ever comprehend the deep, sociological nuances of intent?
It's a great question.
How does an algorithm weigh the CCJS criteria for a suspected hate crime? Can a computer evaluate the 20-year history of a neighborhood or the subtle, sarcastic timing of a slur yelled over a fence? How does an AI accurately calculate the split-second situational awareness required by a lone officer standing on a pitch-black rural highway trying to decide if the shadow in a suspect's hand is a cell phone or a weapon?
It's a daunting, massive question about the absolute limits of technology when it comes to measuring the chaotic reality of the human condition.
It really is.
Yeah.
If human beings, the media, and our justice system already struggle so profoundly to separate statistical fact from emotional narrative and context from malice, how can we possibly expect a machine to get it right? It makes you realize that you can't just look at a spreadsheet and understand violence. You have to understand the people involved.
Well said.
Thank you so much for joining us on this deep dive today. Stay curious, keep looking for the context behind the headlines, keep asking the hard questions, and we'll see you next time.